We are following breaking news. The man accused of shooting randomly on Memorial Drive Monday afternoon is in court for his arraignment. Let's listen in.
All right. ADA Elaine, you're handling this matter.
Mr. Brown, you do have the right to be represented by an attorney in this matter. I've been advised that you are indigent and you are eligible for court-appointed counsel. As a result, Attorney McGowan, Attorney Raisler-Cohen, and the committee have been appointed to represent you. Attorney McGowan, you're available for an appointment?
I am, Your Honor.
All right. ADA Elaine, you're handling this matter for the Commonwealth.
Yes, I am.
All right. You indicated a few minutes ago that the government is moving for detention at this time pursuant to Chapter 276, Section 58A?
That is correct, and the Commonwealth has filed a written motion.
All right, I'll hear you on probable cause.
Thank you. Your Honor, the allegations are that on May 11th of 2026, at approximately 12:10 p.m., a Massachusetts parole officer reached out to the Boston Police Department to report concerns with one of his parolees who was identified as the defendant, Tyler Brown. The parole officer said that Mr. Brown had told him over a phone call that he had relapsed and was using drugs and was ready to end his life. So the parole officer had scheduled a drug screen for that day. The parole officer also said that he knew that Mr. Brown, in addition to his drug relapse, was known to carry weapons and had previously been involved in an officer-involved shooting. He also reported that he had had a meeting, the parole officer had had a meeting with another person earlier that day who expressed some concerns about Mr. Brown because he had been getting high the night before. That parole officer then texted Mr. Brown to say to set up a meeting as soon as possible. So at about 12 p.m. on May 11th, the parole officer reached out to Mr. Brown by phone, but he didn't answer. He was finally able to get a hold of him at about 12:08, and the parole officer could tell that something was not right with Mr. Brown. He said Mr. Brown was expressing suicidal ideations, so the parole officer called 911 and he notified his supervisor. The parole officer got in a car and started driving to Mr. Brown's residence. He knew that Mr. Brown had recently been released from an admission to a hospital on May 8th. When the parole officer arrived at Mr. Brown's residence, which is in Boston, Mr. Brown was not there. And the parole officer received a FaceTime call from Mr. Brown, who was calling from a number that the parole officer didn't recognize. And they spoke for several minutes. It was a video FaceTime call, and the parole officer could see that Mr. Brown was holding a semi-automatic rifle inside of a kitchen that he did not recognize to be Mr. Brown's. The parole officer, based on his observations and communications, believed that Mr. Brown was under the influence of drugs. And Mr. Brown made various statements, including saying that these people are going to pay and I'm not going back to prison. Mr. Brown also was talking about cases, crimes that he had committed that he did not get caught for. The parole officer took a screenshot of what he could see on the FaceTime call and sent it to the police, at which time Mr. Brown ended the call. Parole officer reported what he had seen to Boston police, and the Boston police then obtained a search warrant to ping Mr. Brown's phone number, which resulted in a location in Cambridge. Officers, including Cambridge Police and Massachusetts State Police, started responding to the Cambridge location, which was in the area of Kelly Road. One of the troopers was Trooper Landon Vini, and he started responding along with individual Cambridge units. At some point while this was happening, Mr. Brown called his parole officer again. He said that he was no longer Tyler Brown and he was going to be representing his shooter's name. They talked for another minute or so as he was holding the firearm. He was repeating that he wasn't going back to jail and made suicidal statements again. After that call ended, Mr. Brown began walking down Memorial Drive in Cambridge with that weapon, firing it repeatedly in an erratic fashion. There were two men who were sitting in their cars, and they were struck by gunfire. One was struck in the back of the head. He has since been treated and released from the hospital. Another man was shot multiple times, including approximately 4 times to one leg, which has resulted in serious injuries. He is still currently in the hospital. There was also a woman who was sitting in her vehicle who described a bullet passing through her car very close to her jacket as she sat in traffic. When Trooper Vini arrived, Mr. Brown began firing his gun at him. Trooper Vini and another civilian witness began firing back at Mr. Brown, who was struck multiple times in his extremities. There were also multiple videos from people who were on the street and in neighboring apartment buildings and businesses that documented Mr. Brown's progression and shooting down Memorial Drive. Investigators interviewed the civilian witness who fired back at Mr. Brown. He described that he had been driving southbound on Memorial Drive when he saw multiple cars in front of him stopping and turning around. He said he heard gunshots. He himself is an ex-Marine. He is licensed to carry, and he had a firearm with him in his car. He retrieved it from the safe it was in, and he began trying to help people get out of their cars, get them to safety, while he was firing at Mr. Brown. Once he heard sirens, he saw the police arrive. He had seen also Trooper Vini engaged in firing with Mr. Brown. This witness was not injured, but his vehicle had 2 bullet holes in the driver's side door that were sustained during the shooting. The firearm that Mr. Brown used was recovered on the scene. It was described as a multi-caliber BCI defense model FF-15. There was also a scope on the rifle. The last count that I have revealed that there were over 70 discharged ammunition casings located in that area. Mr. Brown does not have a license to carry. A review of Mr. Brown's criminal history shows that the most recent conviction he has is from 2021 out of Suffolk Superior Court. That was a case where it was very similar to the circumstances here, where he fired upon officers. He was charged with armed assault to murder, attempted A and B by discharge of a firearm for firing at 1 police officer. He was charged with assault and battery, 3 counts of that for pointing his firearm at additional responding officers, and there were related firearm possession and ammunition possession charges associated with that case. He was sentenced to 5 to 6 years in state prison there, and he was placed on probation to run from and after the committed portion of his sentence ended. When he committed that offense, he was on probation also out of a Suffolk case for an assault and battery by means of a dangerous weapon case, where he was sentenced to 6 years to 6 years and 1 day in state prison and probation from and after the completion of the committed portion of that sentence. As a result of the 2021 case, his probation was revoked, and he was sentenced to concurrent time on with this case and the 2021 case. His record also shows that he was convicted out of Charlestown District Court in 2014 for an assault and battery, where he was sentenced to 2.5 years in the House of Correction. In 2008, he was convicted of firearms offenses and sentenced to 18 months in the House of Correction. His III, which is his out-of-state record, also shows contacts with the police out of New Hampshire and Michigan. New Hampshire in 2007, it shows that he was convicted of drug offenses. In Michigan in 1999, it shows that he was convicted of escape. And in 1994, also out of Michigan, it shows that he was convicted of armed robbery. That is the summary of Mr. Brown's criminal history and the circumstances of this case.
All right, thank you very much, Commonwealth. Attorney McGowan, as it relates to the government's recitation on probable cause, do you wish to be heard at this time?
I'm not asking to be heard at this time, Your Honor. We're in agreement as to a prospective hearing date.
All right, well, just procedurally, under the statute, the first finding that I, as the judge, have to make is whether the government has met its burden with respect to probable cause. And based on ADA Elaine's recitation, as well as her written submission, I do find that the government has established sufficient probable cause. As a result, Mr. Brown will be detained pending a hearing on the government's motion for detention. Commonwealth, you're seeking a good cause continuance?
Yes, I've spoken with Attorney McGowan, and we are asking for next Thursday, which I believe is the 21st at 11 a.m.
21st?
Yes.
Okay. And is that a good date for you, Attorney McGowan?
It is, Your Honor.
All right. So I do find there's good cause for a continuance. There's a joint request for a 58A hearing on the 21st. I would just ask counsel, given your client's medical situation, if you can just be in communication with our clerk's office and our court security to determine the place where that hearing may occur, whether your client will still be in the hospital, be at the jail, and then we'll make arrangements to determine if the hearing will be held here at the courthouse or remotely. Would that be okay with you, Attorney McGowan?
Yes, Your Honor.
I also do want to note that there is a warrant, as ADA Elaine mentioned, that we have in our system out of the Suffolk Superior Court, the probation warrant on docket 2084CR369. So, Attorney McGowan, whatever steps or actions you want to take with respect to that, I just want to make sure you were aware that we do have that warrant in our system. But if there's nothing else that needs to be addressed, we'll schedule it for the 21st. But ADA Elaine, did you want to say something?
Yes, just a few more things. There is also, I received this morning a parole detainer for Mr. Brown as well. I provided a copy to probation, and I sent a copy over to Attorney
All right.
McGowan.
Thank you.
There is also on, I think, Tuesday of this week, the Commonwealth filed a motion to impound victim biographical information from the public, which was allowed until the arraignment date, which is today. So the Commonwealth is asking the court to allow the impoundment as it relates to the personal information of the victim.
Sure, and just to be clear, because I want to make sure our clerk's office understands the ruling, I believe on May 12th in front of me, the government moved to redact the name, address, phone number, birth date, and social security number of certain witnesses from the public. The rest of the report and the materials is an available document. Is that your understanding?
Correct, it is
Yeah.
available, yes.
Yeah, so I allowed that motion with counsel present under the uniform rules of impoundment, and I entered the order until today. Does the defendant have any objection to that impoundment order as to that biographical information being further extended at this time?
We do not, Your Honor.
All right, so I will grant that request, and I will order that these materials remain redacted. I'll do that for 1 year. What's a 1 year date, Danny?
May 14th, 2027.
So the redaction order will remain in effect until May 14 of 2027, and Commonwealth, pursuant to the uniform rules of impoundment, if there's a request at that time for a further extension of the redaction, just do so by way of motion, serving it on counsel.
Thank you.
Any other issues from the government?
No, thank you.
Attorney McGowan, any other issues with respect to Mr. Brown? All right. Thank you, everyone. We will next schedule this matter for a hearing on May 21. Mr. Clerk, do you need anything else? All right. Thank you.
Thank you.
I just need to endorse this.
Yes, sir. Mr. Brown, as it relates to docket ending in 652, the court has found probable cause for your detention pending a dangerousness hearing. That hearing will take place May 21st, 2026. Admit to Middlesex for transport to court to issue. All set. Thank you.